Our first speaker is Stuart Rudner. He's a partner at Miller Thompson. Stuart's a longtime colleague. I've known Stuart through interaction, if not through litigation, for a number of years. He's been a very active member of the OBA and well respected within both the organization and the profession. He's going to speak to us about electronic issues in the workplace, something that's coming up on a far more frequent basis than it ever has before. So, Stuart.
Great, thanks, Jonathan. So electronic issues is broad enough that I was asked to cover two topics, one of which is dealing with social networking sites and then general principles of employee internet use and abuse, and the other is electronic documents in the litigation process. And of course I was asked to cover both of those topics in about 35 minutes. I will mention at the outset that two topics, therefore two papers in your materials. And March break is coming up, so if you have nothing else to do, I encourage you to have a look at them. They will cover a lot of what I'm talking about in more detail than I'll be able to do in the next half hour or so. So jumping right in, first of all, talking about social networking websites, it's really just the latest online evolution that has left a lot of employers scratching their heads trying to figure out whether they should be worried about it at all, and if so, what they should do about it. And I say it's the latest online evolution because it's really just, it's every couple of years there's something new. And I do still remember back when I shouldn't say back when I started practice, it's not that long ago, but when I was called to the bar and joined my firm, and at the time, which doesn't seem that long ago, it wasn't automatic that you even had internet access from your desktop. You had to ask for permission to get the access, and I went to a partner in my firm who shall remain nameless. I assume this was a rubber stamp, but effectively what I was told was there's no possible business reason why you would need to have internet access at your desk, and all you're going to do if we give it to you is catch up with last night's hockey games and plan your next vacation, so no, just go and bill some hours now. So of course, being somewhat tech savvy, I then went back to my desk and played around for a few minutes and gave myself internet access and happily used my illicit internet access until the policy changed and everybody was officially allowed to do it. Now we read about the Government of Ontario, the City of Toronto, and a lot of other organizations who are banning their employees from using Facebook at work. And it's really the same issue all over again. In between, we've dealt with people accessing inappropriate websites while at work, inappropriate emails being sent around, chat sites, blogging, and now social networking sites, the biggest of which is clearly Facebook, which grabs all the headlines, and for whatever reason, Canadians in particular are among the most avid users. And Toronto, I'm told, has more users than any other city in the world. And unlike my firm, which at the time just blocked internet access, and unlike employers now who are blocking Facebook access, I would say that it's not necessarily the best thing to do. And if you're advising an employer, I wouldn't recommend just blocking everyone from using Facebook. I don't want to talk a lot about the uses of Facebook. That's not my area of expertise. But I will say that there are legitimate business uses for it. It's a networking site, and think about all the different jobs where part of your duties is to network, including anyone here, especially if you're in private practice. I can say I'm on Facebook, and although I use it for social purposes, I have also generated client work because of the fact that I'm on there. And I have friends who are in marketing type jobs, and they've been there. Some of them are in companies that have decided to ban Facebook altogether. And as a result, to do legitimate work, they've got to go to an internet cafe at the corner and log on to Facebook to help the interests of the company. So like everything else, it's a bit of a balancing, because having said that there are positive aspects to social networking sites, there are also a lot of concerns from the perspective of an employer. First of all, I mean, if you think about, well, first of all, how many people in this room actually have been on Facebook or any other social networking site, just out of curiosity? So, well, a little bit under half, I would say. And the ways in which you can express yourself on this type of site are almost unlimited. And you can go on there and you can join groups which indicate your interests. You can, when you sign on, you're asked what your interests are, what your favorite TV shows are, your favorite quotes, etc. And every day, if you want to, and not that everyone has time, you can update your status and say what you're doing today or what's going on in your life. You can also post comments on people's walls. You can post photos, which all sounds well and good and lots of fun. One of the things, though, that you're asked when you sign up is who's your employer. And if you choose to input that information, or if people just happen to know what company you work for, then by implication, everything you do can be seen as referring back to your employer, and it's easy to see how that could have negative implications for whoever you might work for. I mean, an example I heard of was someone who was working for the Catholic Church, but one of the groups that they signed up for was the pro-choice group. Obvious, inconsistency there, and at least a bit of a concern. I also know someone who works for a conservative political group in one of the provinces, but signed up for the liberal Facebook group. As well, imagine what happens when your clients go online and see a picture of, let's say Jonathan, passed out drunk one night after a stag party.
Impossible.
It wouldn't be Jonathan, which is why I chose you. But if people are looking for a lawyer, they may think twice about hiring the guy that they see in that position. Or on the status updates. I saw a status update once. Someone wrote, well, it looks like I'm going to be working all weekend because our new product launching next week has lots of flaws in it. Now, anyone seeing that and either considering buying the new product or perhaps being a shareholder in the company is going to have a lot of concerns. And these are just a few examples of the ways that you can cause trouble on Facebook or any of these websites. And the other issue, of course, is that while websites change every day, there's generally a permanent record. And if you do a Google search and you look at cached sites, these things stick around almost forever. So from an employment law concern, there's really two broad areas to look at. One is employee use at work, and the other is employee use off-duty. And the rules are fairly different from one to the other. First of all, talking about use at work, there's really three types of behavior that can cause a concern. One is just the innocuous web usage or networking site usage where there's nothing offensive or inappropriate about it. It's just that you're doing it while you're supposed to be working. The other is usage that would be inappropriate, either in relation to other workers, i.e., putting up a screensaver that has offensive images on it, or inappropriate to the organization, like posting things on Facebook that are detrimental to your company's interests. Another great example was a truckload of Apple computers. There was a photo of a truckload of Apple computers being delivered to Microsoft's head offices, and that was posted on Facebook. And then the third, just to finish that thought, the third type of behavior at work that would cause a concern is obviously anything illegal, which if being done on your employer's equipment is obviously a cause for concern as well. Starting first with the what I call the innocuous use. There's no question that if people have internet access, they are going to use it at least part of the time for personal reasons. And courts have, and arbitrators have looked at what is appropriate in terms of a policy, whether you can, whether you should allow people to do that at all, whether you can ban people from doing it. From a pragmatic perspective, I think that the prevailing view seems to be that it's just like using the telephone. You're not going to be too concerned if someone makes a couple of quick personal calls during the course of their workday, especially if they're a salaried employee who isn't necessarily there from 9 to 5. And likewise, if they're on the internet for a couple of minutes here or there, attending to personal matters or even just catching up on the news, you shouldn't really be particularly concerned about it. But when it gets to the point where they are neglecting their duties and wasting their time at work, that's where it becomes time for either discipline and ultimately dismissal if it gets to that point. In the paper, I've included some statistics. Some of them are a little bit outdated now, but the time spent on the internet while at work is absolutely staggering. And what people will do while at work is also quite shocking, especially when you consider that most of the people are either at cubicles or other areas where other people can generally see what they're doing, and it doesn't seem to stop them. So there's good reason for employers to be concerned and to take measures to control internet use. Like anything else, a lot of it will depend on the context. If you're talking about a factory worker, there may not be any reason for them to have internet access at all. If there's no business reason at all, don't provide it. But otherwise, if you're talking about someone who's at a desk, uses a computer anyways, the common sense approach seems to be, as I said, like a telephone. Minimal usage is okay for personal reasons. Once you get beyond that, it may be time for some sort of discipline. Social networking sites can cause many concerns, but one of them, and I think the primary one, is just the excessive uses. And I've had more calls from clients than any other type of internet usage in relation to Facebook. And they have people who are spending, or seem to be spending, hours every day on Facebook, and usually they notice it because there's a spike in the bandwidth usage, and when the IT people go to find out what's going on, they realize that people are on Facebook almost all day. So it's not a new issue, but I think it's becoming a bigger issue in more recent times with the advent of Facebook and the other social networking sites. In the paper, I go into this in more detail, but there are a lot of other types of usage at work that cause concern. I'll talk about a couple of them quickly and some of the cases that have considered them. First of all, there's porn sites, and somewhat related are hate sites, not as popular for whatever reason. But there's been a lot of consideration about what is and is not appropriate to do while you're at work, and then going right along with that is when can you discipline, when can you dismiss someone for accessing inappropriate websites while at work. And there's some really, the courts and the arbitrators seem to have really drawn a spectrum from the relatively inoffensive type of websites to the really, really bad type of websites. And the discipline that is appropriate will depend, among other things, on where the usage falls on that spectrum. It'll also depend, too, on things like where it's being done. There are a lot of cases, not so much in the last few years that I've seen, but particularly in, I'd say, the late 90s, early, whatever we call this decade, where people were just displaying inappropriate websites on their computer for everyone to see, forwarding the inappropriate emails, etc. It seems to have been curtailed somewhat in the last few years, perhaps because employers are adopting better policies, and I'll talk about the use of policies. One good example, though, about the importance of having a policy is a case I've put in the materials where someone was found to have images of sunshine girls, which you might see in, for example, the Toronto Sun, had, I think, 24 images on their computer, and they were disciplined for it, and then ultimately was found that while this may have been inappropriate, it wasn't clear that pictures of sunshine girls who were scantily clad but not unclothed was not so objectionable that it could form the basis of a dismissal. But what you can take out of that case is it's important to have a good policy, because if your policy defined what was inappropriate, you could easily define it to include things like images of the sunshine girls. So that would allow you to extend the application of dismissal to something that a court might not otherwise agree with. There's also some interesting cases that talk about what type of actions will be cause for discipline or dismissal. Typically, you would think it would be disseminating this type of information or storing it on your computer. But there are cases that have said that just the mere receipt of inappropriate material can be grounds for discipline. In situations where you're receiving these things, and even if you delete them right away, some cases suggest there's almost an onus on the employee to reply and say, don't send me these materials anymore. And if you don't do that, then you could be disciplined for continuing to even just receive them, even if all you do is delete them upon receipt. There are some cases as well in the materials talking about, they're under the headings of gaming and gambling sites or chat rooms, all of which are other concerns if you've got people who are at work on gambling sites, gaming sites, and chat rooms. But most of them seem to come back to the fact that the real issue was not what they were doing, it's just the fact that they weren't doing their job. One of the cases, and this is a low-tech case in the materials back in the dial-up days, is a guy who unplugged the company fax machine in order to dial up to the internet and play online games. Now, the problem was that this guy worked at a small airport, and he would receive weather updates, which would be pretty important for people to know whether it would be safe to land. But he'd get these weather updates by fax. But on the day in question, he had the fax machine unplugged for hours at a time while he played online games. Thank God there were no crashes. But it's easy to see how this was cause for dismissal. And similarly, I don't know why it's always guys in safety-sensitive positions, but in a Calgary case, someone who was in a chat room for hours, and his job was essentially relating to the safety of the municipal drinking water. And there's an alarm that's going off, and he's supposed to respond to it and find out if there's a problem with the drinking water. And what the company found is that at the time when this alarm was going off, apparently for a couple of hours, he was online chatting away on a chat site and completely ignoring his duties. So a lot of it seems to come down to not really what you're doing, unless it happens to be something offensive, just the fact that you're not doing your job. Downloading copyrighted material is another big one, and recently, although not, I guess not in the last couple of years as much, the big thing was music downloading, and to some extent movie downloading, video downloading, and just downloading copyrighted software. There's obviously some legal implications for the employer if you're doing it on their computer, and potential liability, so most companies will have policies in place to cover that. The irony in the cases that I've seen, and some of them are in the materials, is it's always the IT guys who are doing this, and they're the ones who put the electronic mechanisms in place to block you from downloading things, but they're the ones who know how to get around those blocks and download the copyrighted materials. So in a number of cases, you've seen people bypassing the safety measures, downloading copyrighted materials and exposing their employer to liability. The other, I guess, big concern, and this can apply equally at work or if you're using it at home, is harassment. It's pretty easy, if you're somewhat tech savvy, to harass someone anonymously online, be it through email, be it on a group or a site like Facebook, where you can post things about people, you can post inappropriate photos of people, etc. And especially with the recent topic, which I think is being discussed later, of psychological harassment, certainly a cause for employers if they become aware of the fact that any of their employees are being harassed online by a fellow employee, or even worse, someone in management or a supervisory position. These are not issues that are new. Harassment has been going on for presumably as long as people have been working. It's just that this is a new way to do it. And that's really a theme when you look at the law generally, and what I've said to a number of groups like this is, the good news is that while the types of websites, the types of internet and email usage keep changing, the law really doesn't. The law is the same as it was before people started using the internet. It relates to what you can and can't do either at work, and also when you can be disciplined for off-duty conduct. So the law is the same, and I will talk briefly about that. It's just being used to or applied in new and relatively frequently changing circumstances. As far as off-duty conduct, which really seems to be the one that gets more headlines, you've read probably over the last number of years about people being fired for blogs, people being fired as well for Facebook activities, including someone who worked in a grocery in Canada, and their Facebook postings at least strongly suggested that they had also been stealing from their employer, and that was used to as just cause to fire them. Go out onto Facebook, though, you'll find groups, and I'm just picking on Tim Hortons because I walked by there on the way here. I don't know if this group actually exists, but you'll find groups like I work at Tim Hortons and they treat their employees terribly. So these are obvious things where even if you're not doing it at work, it's going to be a concern for the employer. And like the examples I gave earlier where you might be joining groups or posting things that are inconsistent with your company or your organization's goals, all of these things are going to be a concern for your employer whether or not you're doing them at work. And the law has effectively, in terms of when you can discipline someone for off-duty conduct, I mean, you don't really care how much time they're spending online if they're at home. You don't really care if they're accessing inappropriate websites at home. But if they are doing things that damage your company's reputation, that can be grounds for discipline or dismissal. If they are doing things that render them unable to perform their duties, that can be grounds for discipline or dismissal. Or if they are doing things that make it essentially impossible for their managers or other staff to work with them, again, that can be grounds for discipline or dismissal. Or anything that really negatively impacts upon the ability of the organization to carry on with whatever business they're involved in. And one of the things that you often see when these things come into get into the press is, well, what about freedom of speech? And there was the situation maybe a year or so ago where a number of high school students were suspended because of their Facebook postings, and all of them and I think their parents were quoted as saying, well, we have freedom of speech in Canada, and how can they be suspended from school because of what they post online when they're at home? And of course, freedom of speech doesn't prevent you from being suspended at school. Freedom of speech doesn't prevent you from being disciplined or dismissed from work if you are doing things that are contrary to the interests of your employer. Should try to move on fairly quickly to talk about electronic documents. The key message that I think we as lawyers, if you're advising employers, should give, and if you're advising employees, it would be to inquire as to whether these things exist, is what has been done with respect to policies. Because if you read the case law, and if you read the case law, most cases will look at whether there was a policy in place dealing with the particular behavior that the employer is relying upon for the purpose of discipline. It's crucial to have a policy. That's step one. Unfortunately, that's where a lot of companies stop. I know of a lot of companies who have drafted great policies, and then once it's finished, it goes in a binder, goes on a shelf, collects dust, and that's almost as bad, if not as bad, as not having a policy at all. The second step is to disseminate the policy. Make sure that every employee is aware of it. Ideally is given a copy of it or given access to it on the computer, and also that there are regular information sessions to make sure that new employees are aware of the policies and everyone is aware of new policies. Which gets me to my next point, which is maintaining and updating policies, especially when we're talking about online usage. No policy that was drafted 5 years ago is going to talk about Facebook. But the reality is that's something you now have to deal with. So I encourage any employers that I advise to update their policies very regularly, very frequently, to talk about new issues as they arise. And you can phrase them generally enough that you don't have to talk about every new website. But when something like social networking sites comes along that really didn't exist in the same way in the past, you should have a policy that talks about it specifically. And the last thing that employers should do is enforce whatever policy they have in place. Because if you don't enforce it, it's going to be easy for an employee who is disciplined or dismissed for breaching the policy to say effectively, well, everybody else was doing it and I shouldn't be penalized. And courts and arbitrators will certainly look into whether that's true. And there are a lot of cases, some of which are in the materials, where discipline or dismissal was not upheld because although there may have been a policy that says thou shalt not do this, the reality is that it was what was deemed to be a permissive workplace, and everybody was doing it. Management knew about it and did nothing to stop it. So, as I said, it's really 4 steps: have a policy, disseminate the policy, update the policy regularly, and enforce the policy. And within the policy, it's important to define anything that might be subjective. Getting back to the Sunshine Girls example, if you define what's inappropriate broadly enough, then you can capture things like that might not otherwise be subject to discipline or dismissal. And if you look in the paper on this topic at page 17, there's actually a useful set of guidelines as to what you should have in your policy, how you should draft it. But the important thing is just to cover as much as you can, define anything that's subjective, while at the same time, of course, leaving yourself enough wiggle room to cover new things as they come up. Sounds easy, of course, it's not as easy in practice. But if you're advising employers, as I say, I strongly suggest that you give them that advice. And if you're advising employees who are subject to discipline, look at whether those practices have been followed. And with respect to discipline, it's just like any other situation where a just cause might be alleged. We have to take a contextual approach, and the courts will look at a lot of factors in considering whether discipline for online usage was appropriate, and I've put a number of those at page 21 of my paper. But just like any other situation where you're going to discipline someone, it's important that the employer gives warnings, uses them appropriately, builds up a case if necessary, uses discipline. And of course, there's still that murky area of what type of progressive discipline is allowed in the non-unionized context. But it's important that employers use discipline properly before going to the step of dismissal. So given that I've got about 12 or 13 minutes left, I'm going to move on to electronic documents and talk about that. And there's really two aspects to this issue. One is dealing with your clients, educating them on what they need to produce if there is going to be litigation. And the other issue is dealing with the other side in terms of what's going to be produced in litigation, how it's going to be produced, and in what form. We all need to be able to advise our clients on what is required of them, and we all have to realize that in today's day and age, the vast majority of new documents are never printed. Most of them are maintained in some sort of electronic format and don't see, well, I don't know if the light of day is the right expression, but they don't see paper. But you still have an obligation to produce them if they're relevant. And of course, as we all know, the scope of relevance has been defined extremely broadly traditionally in litigation. And while electronic discovery may be changing that to some degree, the reality is if anything has a semblance of relevance, the rule is you're supposed to produce it. I will say now, just in case I forget to at the end of my presentation, the OBA website has some tremendous materials with respect to electronic discovery, so I urge you to go there. You can find the guidelines that I will talk about briefly. You can also find some excellent precedents in terms of letters to your client, letters putting the other side on notice, etc. So I'd suggest that you have a look at those. When I say that discovery is changing because of the use of electronic documents, I mean, in the employment law context, in the old days, if you were acting for an employee, you'd get them to send you whatever documents you had that were relevant, and it might be the offer letter, the termination letter. They'd probably send you a couple of really good reviews, and that might be about it. And if you were acting for the company, the HR manager or whoever your contact was would send you the employee file, which would have the offer letter, the annual raises, the reviews, maybe a couple of memos to file, and ultimately the termination letter. And that would be about it. Now we're looking at a situation where there's electronic documents that have to be produced. And in terms of how they differ from the old types of documents and files, and first of all, it's just the sheer volume of them. I mean, think about the number of emails we get, and think about how many people we either forward them to, or we reply back and forth 17 times on the same email, which creates 17 documents, or we copy people with the email, or we blind copy people with the email. That creates in and of itself a tremendous number of documents. If you're using Word or any other word processor, you probably have an auto-save feature which creates draft versions of the document as you go. So you can, and as well, you can have copies of the same document in a dozen different places. And I was actually thinking about this on the way over here today as to how many different sources of electronic documents I had on me just on the walk over here, and I came up with 5, I believe. And this is just walking from my office to the OBA. I've got my laptop computer with me. I've got 2 USB keys. One's on my keychain, one's in my bag. I've got a DVD with some documents on it. I've got a CD with some documents on it. And, of course, I've got my BlackBerry here with God knows what on it. The sources of documents are the other big change. In the old days, as I said, most of your documents were found in the file, and it was pretty easy to copy the file and send it off. Now, I mean, documents can be held by any number of people. They can be found on people's desktop computers, on their home computers, on their laptops, on their USB keys, on their cameras. You can put a memory chip or a memory card into your camera, on their phones. Think about the documents you might have on your phone. In one case, I knew of someone who had surveillance video, and the easiest way they could think of to watch it was by putting the, I guess it was a memory card or USB key, whatever, into their kid's Xbox 360 and watching the video at home. And I don't know if they did or not, but if they'd copied it onto the hard drive of the Xbox, well, there's another source of documents that might have to be produced in the context of litigation. So that's another big change from the old documents that are all in the file. The other issue, of course, is the easy manipulation of electronic documents. I mean, think about how easy it is to go in and edit a Word document at any time. Or any other type of, Excel, any other type of document or database. And that's talking about intentionally manipulating a document. The reality is, just by turning on your computer and opening Windows, you are probably changing a couple of hundred files on your system, because every time you start Windows, there's a bunch of log files and other things that get changed. And in some situations, that can be relevant too, as far as when the computer was accessed, who accessed it, etc. And just by turning the computer on, you're changing the information. You're changing the documents. And of course, think about web pages that change, in some cases, several times a day. And if there's an issue about what a web page said on April 17th, 2006, well, that's probably not going to be the web page you find when you go to the URL today. So you have to be aware of the fact that documents that may be relevant to your litigation, and you may not get to court until 2 years from now, but you have to figure out what the document was at the relevant time. In terms of what electronic documents are, there's a really good list in the paper, and there'll be things that you don't necessarily think of. For example, voicemail messages. How many people produce voicemail messages when they're producing their affidavit of documents? Probably not many, if anyone in this room ever has. But there will be situations where a voicemail message will be more relevant than any email or letter or memo that you have. Internet pages, as I said, data files, videotapes, sound files, etc. All these things are electronic documents. All these things are producible if relevant. And then the next question, as I talked a little bit about already, is where do you find them? And again, there's a pretty good list in the paper. I've talked about desktop computers. There's network drives. I mean, even the printer in my office keeps a log of exactly what was printed, how many pages, and when. And that type of thing can be relevant. Answering machines, if anybody uses those anymore, voicemail systems, digital cameras, pagers, all of these things contain data, contain log files, which in the right case, I'm not talking about the standard wrongful dismissal where the only issue is the length of notice, but in the right case can be extremely important, and going by our traditional practice, you may not think of looking there. But it's something that we all have to keep in mind, because we do, or at least we're supposed to produce everything that is relevant, and it becomes harder when there's no management of who's got what document, how it's disseminated, how it's stored. Which is the other issue, is of course all these documents are in dozens of different formats, and how do you produce them? How do you produce a database that someone has on their computer that might have 150 different fields? 3 of them are relevant to the action. You can sort this database in a million different ways. You can search for particular pieces of information. How you produce it can be the source of tremendous debate. Which gets me to something that I did want to mention. I don't know how many people here have tried to do an electronic discovery. I've done it on a couple of occasions with mixed results. I mean, it was great in the sense that I wasn't lugging boxes of documents with me to the discovery, but at the same time we spent a lot of time during the discovery with my counsel on the other side having one document on their screen and I had a different one, but maybe it had the same date, or we had different versions of the same document, and we wasted a lot of time. And what I realized, and you'll see this in the guidelines that are produced there on the OPA website, the key really becomes communication. I mean, most of us don't really talk to opposing counsel about productions all that much unless there's a complaint about them. Traditionally, whoever is inclined to move the action along, typically the plaintiff, will produce their affidavit of documents, send it off, and say, I expect yours within 30 days or whatever. And maybe say, please send me your Schedule A documents as well. That's about it. What I realized, though, in going through some electronic discoveries is even though we'd agreed we're going to produce the documents electronically, we didn't really talk about how. So he used summation, I used summation, he used a different type piece of software, so they couldn't really communicate with each other. And we'd have situations where the fax cover page was document 3702, but the letter that was sent along with it was document 8743. And to try to find those two and put them together was almost impossible. If we had communicated, the software that exists now, like summation, can easily create links between those two documents, and you can make your electronic discovery incredibly efficient, but the key is to communicate. The other important thing to remember, since I've got my 5-minute warning, is when dealing with electronic documents, they're not like printed documents. They contain, obviously, whatever the document says, just like a document that's printed. They also contain hidden data. There's 4 types of hidden data. You'll see this in the paper. But the most important one, really, that I want to talk about is metadata. Metadata, the best way I can define it is data about data. So if you've got a Word file, the Word file might say, we're pleased to offer you a job. We look forward to seeing you next week. But the metadata might say that this letter was drafted on June 4th, 2006, Then it was edited on June 16th, 2006. It was viewed by Jonathan and two of his partners. Then it was edited again, and it was finally printed on July 27th. And that may or may not be relevant, but these are all things you can glean from having the electronic document that, of course, you would never know if someone just produces the printed document. So it's easy to find out a lot more about what happened by requesting the electronic documents if they're going to be relevant. The other thing about electronic documents, of course, is that people tend to use them very carelessly, and as a result, there are trails of conversations that never existed in the past. In the past, the HR manager might have a discussion with someone and decide to terminate an employee, and that was a verbal discussion. And, of course, they might give their evidence about what the discussion was, but you'd be relying upon their memory. Now, people tend to do it by email from their BlackBerry, quick voicemail message, and those things linger, and I've seen cases where they've come back to haunt employers. So something to be aware of, that often the information is out there. You can get it if it's the right type of case. I'll move on quickly because I've only got a couple of minutes left. One of the other issues, of course, is the fact that when you're talking with the other side about, hopefully you're talking with the other side about how you're going to produce documents, the guidelines that have been produced in Ontario with respect to electronic discovery essentially try to strike a balance. It's reasonableness, it's looking at the burdens. You have to look at the type of case to decide even whether electronic discovery is appropriate at all, or whether you should just be acting the way you always did and printing a bunch of documents or photocopying them. And what they've effectively said is, look, if the metadata is going to be relevant, you've got to produce the electronic version of a document. If all that matters is what the letter says, then just print it and send it along, and the same thing would apply to emails. The guidelines also suggest looking at things like the cost, because the cost of producing every email that may well be relevant can be prohibitive if you're talking about a $15,000 case. So you look at the cost, you look at the amount at stake, and of course the relevance. And the principles also talk about the fact that before you even, ideally even before you get into litigation, if you've had discussions with the other side, you talk about what the issues are going to be, you talk about what the documents may be that are relevant, and you put both sides, both your client and the other party, on notice that you may require electronic documents, and you can get them to effectively freeze those documents. You can create a mirror image of a hard drive and get a copy of the document as it exists at that date, so you're not trying to recreate it 2 years down the road. You can also talk with the lawyer on the other side about what searches will be done. If you're talking about a database that may contain millions of pieces of information and you suspect there may be some relevant ones, you can agree on what the search parameters will be. You can also agree on how things are going to be produced, and often what I've seen people starting to do now is you draft an affidavit, and this says these are the measures that we're taken to try to locate every relevant document. These are the searches we did, and we came up with what's in our Schedule A. And in many cases, that will be perfectly appropriate. And if there's a problem with the search terms, well, then you can discuss it with your opposing counsel and hopefully reach an agreement, or if necessary, get an order as to what searches will be conducted, all within the context, at least from the guidelines and from the small number of decisions that we have so far on this issue of reasonableness. You have to look at the cost. You have to look at whether these documents are relevant at all, and then you consider how broad the scope should be. The other thing to be aware of is costs. A lot of times one party will request electronic discovery, the other side will say, great, but this is going to cost me $200,000, who's going to pay for it? And the default is still that the producing party has to bear the costs of locating and producing the documents, but there is movement on that front, and I think that the courts have made it clear they're prepared to consider, in the right situations, shifting the cost burden to the other side where it's appropriate. I think my time is effectively up. I see the stop sign. Before I step down, if there are any, can I take questions?
Yeah, please do.
If there are any questions, either in the room or online. No one wants to create an electronic document by sending me an email.
There we go.
All right, well, thanks very much.